Hello, this is Larry Parman, sitting here with Jerry Schiele. We're delighted to be with you again today. Today we're going to cover a topic that's very, very important. It's a central part of our practice. Our practice concentrates exclusively in estate planning, elder law planning, and business planning, and we use the Revocable Living Trust to a large extent in our planning. So today we're going to talk about that, what it is, how it works, what the advantages are, some of the disadvantages, and be sure that at the end of the program you have a pretty thorough understanding of a Revocable Living Trust. So Jerry, start us off and just tell us what a trust is.
In simplest terms to me, is a trust is nothing more than a box. It's a container that we're going to transfer our assets into so that we have control over them. So we take the box, we retitle our home into it, we title our cars into it, we transfer our bank accounts into it, we close the lid, we lock the door, we're in charge. So we created it, we manage it, we're the beneficiary of it. But what it really entails is it's a standby device. It's no different than us as long as everything works normal. But what happens if I become disabled? It has planning in place so someone else can take over. What happens if I need to go into a nursing home? What happens if I die? What happens if my wife remarries? What happens if my children get divorced? So we have all these planning contingencies that we can build into this to simplify things for the family, for us during our lifetime, but for our family after we're gone as well.
I think that's a key point because some estate planning documents help you during your lifetime and then terminate at death, such as a power of attorney,
Right.
which we'll cover in another session. The will doesn't do anything for you during your lifetime. It picks up only after you die.
Right.
But the trust has provisions that will protect you during your lifetime and then after you're dead, acting as a will substitute to transfer your property. Let's go back though a little bit to the beginning, and you alluded to this. A trust is a contract.
Right.
It has three parties. Every trust that's been created has three parties. So it has parties sometimes referred to as a grantor or trustor, and those are the people that create the trust, right? Has trustees, that's the second party, they manage the trust,
Right.
and beneficiaries get to spend.
Correct.
So for those of you listening, if you created a trust, you would be the trustor because you own the property and you're creating the plan.
Right.
You would also want to continue to manage the assets just as you do today, so you'd name yourself as trustee. And then finally, you'd want to keep spending it, right? And which is what beneficiaries do, so you'd name yourself as the beneficiary of that trust as well. So once it's created, once that box, as you referred to it, is created by those three parties, what happens then? What's the next step to make that trust really work effectively for the client?
Well, we need to, number one, we need to get all the assets retitled into it. We need to file public notice so that people know who has authority to act on behalf of the trust. And tied in with the trust, we need to have the other ancillary documents in place that are going to help facilitate the estate planning requirements.
So the key point you're making is that contract, which we label a revocable living trust, and by the way, this is revocable, meaning that you can change it, amend it, modify it anytime you want, meaning that you as trustor keep total control over the whole plan. It will only operate on property that's titled in its name. Correct? So to make it really work effectively, you have to connect all of your assets to that trust by changing title.
Correct.
Okay. So we're going to pick up a little bit more on that down the road. But before we close, just share with them what the big advantage is that people hear about all the time in terms of a revocable living trust compared to a will or other planning options.
Well, the primary advantage, of course, is that we avoid all the emotional, financial, and time-consuming stress that comes from a probate. The trust can be handled administratively. It's a private document. It's not subject to public record. It's not subject to court supervision. And so the process is a much less stressful one, much less expensive one, and much quicker process to go through to transfer those assets to the appropriate people at the appropriate time.
And you would agree that, I mean, a trust contains many, many, many advantages beyond that. That's the big one people talk about. But it can include, and should include, Medicaid triggers, IRA provisions, and so on and so forth, as well as affording protection from estate tax to the maximum allowed by law. So we are strong believers in the Revocable Living Trust as the foundation of your estate plan. We go beyond that. We use the term a legacy wealth trust because it's not just a death planning document. It protects you during your lifetime as well. It gives you the opportunity to pass on the wisdom that you have to future generations. We've talked about that as well in previous sessions. So that's a quick overview of the Revocable Living Trust. If you have more questions about that, call me or Jerry Schiele. This is Larry Parman. We can be reached at 405-843-6100. Talk to you next time.